Is liberty dying where you live? Escape to Keene at freekeene.com.
Fix cameras so that you're not catching the jury, correct?
That's correct.
Yep. Yeah, I'm getting no further
Wait.
anywhere.
Okay. Good enough.
Ladies and gentlemen of the jury, would you please stand? And Ms. Ager, would you please stand and face the jury during the oath? Ladies and gentlemen of the jury, would you raise your right hand and keep it raised during the oath? And at its conclusion, would you each say, "I do"? Do you solemnly swear or affirm that you will carefully consider the evidence and the law presented to you in this case, and that you will deliver a fair and true verdict as to the charge against the defendant, so help you God? I do. Thank you. Members of the jury may be seated. Please listen to reading of the charge. The docket number is 2011 S1052. The undersigned complains that Catherine Ager of 6 Mystic Place in Keene, New Hampshire, at 351 Chestnut Street in Manchester, New Hampshire, on the 4th day of June 2011 at 4:45 p.m. in said county and state, did commit the offense of resisting arrest or detention contrary to statute and the laws of New Hampshire, for which the defendant should be held to answer, in that the defendant did knowingly physically interfere with a person she recognized to be a law enforcement official seeking to effect her arrest when she struggled with Officer Elston, Sergeant Muchi, and Sergeant Patty as they attempted to handcuff her against the peace and dignity of the state. Ladies and gentlemen of the jury, the defendant, Catherine Ager, has been arraigned on this charge and has pled not guilty, and of this she puts herself upon her country for trial, which country you are. The Assistant County Attorney, Charlene Dulac, has joined the issue, and you are to say by your verdict if the defendant, Catherine Ager, is guilty of the offense whereof she stands charged or not guilty. Hearken to the evidence. Thank you.
Good morning, ladies and gentlemen. Let me just give you some preliminary instructions before the attorneys begin. First, let me say that notwithstanding the presence of video equipment in the courtroom, and just so you know, the videographers have been instructed clearly that they are not to be photographing you. They are photographing the witnesses. They can certainly take as many pictures as me as they want, and of counsel and Ms. Ager, but they are not to be photographing you, and they've confirmed that, and that's court order, and they understand it, just so you know. But notwithstanding the fact that, that there are cameras in the courtroom, this is not television. And you shouldn't expect this case to proceed as cases do on television. Television is entertainment. This is real life. This is not Boston Legal or Law and Order or any of the or The Good Wife or any of the new TV shows. And you shouldn't expect what happens in this courtroom to bear any real resemblance to what goes on. If any resemblance to what actually happens on TV is serendipitous. They don't follow the law, they follow the script. And they're dealing with entertainment here. We're dealing with serious business. We're dealing with the way our justice system addresses accusations against our citizens. And I trust you will see the process unfold in a way far differently than it unfolds on television. I wouldn't expect Attorney Dulac to conduct herself as attorneys do on television, and I wouldn't expect that I would conduct myself as judges or those people that are acting as judges that do on television. You, as the jury, are the finders of fact from the evidence. The evidence in this case will be the testimony of witnesses, and there are some exhibits that will be introduced into evidence as well, some videotapes. The order of the trial is as follows. You will first hear the opening statements by counsel. The state, because it has the burden of proof, will go first, and then Ms. Ager will have an opportunity to address you. Opening statements are not evidence. Opening statements just allow the parties to preview what they think the evidence will show from their particular points of view. After the After the parties have provided you with their opening statements, we'll move to the taking of testimony. The state, because it has the burden of proof, will call its witnesses first. Attorney Dulac will examine those witnesses. That's called direct examination. Ms. Ager will be given an opportunity to question the witnesses as well. That's called cross-examination. There may be redirect and recross examination as well. When the state has concluded its case, it will rest. As you know from the general instructions you got when you were first selected, and I think from the instructions that I just gave you during the voir dire portion, the defendant is presumed to be innocent, and she has no obligation to produce any evidence whatsoever. The burden of proof in a criminal case remains with the state to prove its case beyond a reasonable doubt throughout the course of the trial. During the course of the trial, there may be objections made. Either party can make objections, they are simply seeking to enforce the legal rules of evidence. The parties may come to the bench for a further discussion about the bases for their objection. You should draw no inferences from the rulings I make on objections, and you'll hear that instruction again at the close of the case. When all the evidence is in, Ms. Ager and Attorney Dulac will present their closing arguments. Once again, those arguments are not evidence. They simply give the parties an opportunity to present to you what they believe the evidence has shown, but ultimately the decision is yours. At the close of that portion of the case, I will instruct you on the law. And after I instruct you on the law, you will then deliberate to reach a verdict. We will break during the course of the trial at regular intervals, but if you need a break for whatever reason, and we haven't announced the break, just raise your hand and we'll take a break. Let me just say that if during the course of the trial you have any questions, something arises that you're not sure about, a process or a personal matter, or something that has arisen that you believe should be brought to my attention, do not discuss it with other jurors. Bring your problem to the bailiff's attention, and he will then inform me and I will address it. But do not discuss any issues that might arise, personal concerns that might arise with fellow jurors. Once again, you just heard me say it about 15 minutes ago, but you're not to discuss the case with one another or with any third parties or engage in any independent research until the proceedings are over. You will discuss the case when you retire to deliberate. Attorney Dulac.
Yes, Your Honor. Thank you. Good morning, ladies and gentlemen of the jury. This case is about Catherine Ager, the defendant seated right over there, who physically resisted when members of the Manchester Police Department tried to arrest her. Today, you're going to hear from Sergeant Patty, Sergeant Muchi, and Officer Elston. They're all members of the Manchester Police Department, which I'm sure most, if not all of you are aware, is right here in Manchester in Hillsborough County. They're going to tell you today about their interactions with the defendant. They're going to tell you in their own words what happened that day. Prior to them coming and taking the stand and telling you in their words what happened, I'm just going to give you a brief overview of the testimony that you will expect to hear, and also what the state's burden of proof is in this case. What I have to prove to you during this trial in order to convict the defendant of resisting arrest. So let's start with the facts. On June 4th, 2011, you're going to hear that there was a number of people, about 10 to 15 people outside the Manchester Police Department. They were writing on the walls, graffiti. They were writing with chalk on the walls of the police department, the retaining walls, and on the sidewalk. Because this is the crime, the police were investigating this crime, and they were taking pictures as evidence if they needed to use it at a later date, or what we call preserving the evidence. So they were taking pictures of the markings on the sidewalk, on the walls, things of that nature. While they were doing this, the defendant was standing on the sidewalk, standing on some of the chalk graffiti that was there. She was also standing in front of some graffiti that needed to be photographed. You will hear that Sergeant Patty asked the defendant to move. And instead of just moving, she tried to argue with him, and she didn't move. And he ended up telling her she was under arrest, and he goes to arrest her. When he attempts to handcuff her, you will hear that she starts struggling with him. Two other officers have to assist him in handcuffing the defendant, and that is Sergeant Muchi and Officer Elston. Those are the other two officers that have to assist him in handcuffing the defendant. You will also see a video. Quite a bit of it was captured on a video, and you'll be able to see that as well. It's a little hard to see, but you will be shown that video during the course of this trial. You'll also hear the defendant telling him to get off of her, but using some swears when she's doing so. The defendant's physical act of struggling is why we're here today. That's resisting arrest. When an officer is trying to arrest you or detain you, you can't fight back. You submit to the arrest. That is the law of the state of New Hampshire. Whether you believe it's legal or illegal, you don't resist arrest, and there's a reason for that. It's for the safety of officers and for the safety of everyone else around. In order to convict the defendant of resisting arrest, there's 4 elements to it that the state needs to prove to you beyond a reasonable doubt. The first is that the defendant acted knowingly, meaning that she was aware of what she was doing, that she physically interfered with another person, and that she knew that the other person was a law enforcement official, and that the official was trying to arrest or detain her. Well, when you see this video and when you hear from the officers, they're in full uniform, they're outside the Manchester Police Department, and they'll tell you that she resisted that day. The state is going to prove all of these elements to you beyond a reasonable doubt, and at the end of this trial, I'm going to appear before you again and ask that you find the defendant guilty of this crime. Thank you.
Sager.
Hi, my name is Catherine Ager. Thank you for taking time out of your busy days to come here today. We're here because on June 4th, 2011, I allegedly resisted arrest, delaying the arrest by 1 second. You'll see 2 videos today, and in the first video, it will begin with me standing on the corner, watching police officers a few yards down the sidewalk, talking, and then you'll see that nonchalantly they form a semicircle around me, and then Sergeant Patty politely asks me, "Excuse me, would you get off the chalk, please?" I was a little bit confused because I did see that there was chalk on.
Objection to the mayor.
Roach.
I'm telling the jury what I believe the videos will show, and I'm telling them what happened. Was aware of and unaware of. So you'll see 2 videos today, and in the first video, you'll see that I was standing on the corner of Merrimack and Chestnut Street over by the police department, watching multiple officers chat outside the police station, and one of them was taking photos. And the video will show that they approached me and slowly formed a semicircle around me, and then Sergeant Patty asked me, "Excuse me, would you get off the chalk, please?" I responded, and the way I responded was in confusion, and then he said that it was the scene of a crime. So I tried to ask him a question. He would not give me time to answer the question. He just interrupted, and then he said it was a lawful order, and I tried to ask a question, and within a few seconds, he reached out with his right hand and grabbed my left arm. He was facing me, and then he used his left hand and put it behind my right shoulder so that he could turn me. And at that time, the way I was turned caused me to sort of lose balance, and you'll see in the video that they lowered me to the ground where I lay not struggling while they applied the handcuffs to me. As she had mentioned, I was telling them in the video to get off of me, and I probably did not use the most ladylike language, but it was kind of upsetting to be physically jostled around, especially when I made no movement or effort to run away or to prevent them from arresting me. So I'm here a week before my high school graduation in hopes that the truth will be seen about this matter, and it will not follow me, and that at least one of you will say that I don't belong in jail for a year.
Objection, Your Honor.
Yes, members of the jury, the issue of punishment is for the court to decide. Whether if you convict her, she goes to jail or not is my decision to make. And you will hear in the closing instructions that the issue of punishment is not for the jury to decide. The issue of punishment is for me to decide.
Thank you for your attention.
The state can call Sergeant John Patty to the stand.
Please remain standing, and there's one more.
You swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth under pain of the penalty of perjury.
I do.
Please have a seat. Could you please introduce yourself to the jury, spelling your last name?
Yes, my name is John Patty. Last name is spelled P-A-T-T-I.
Tell the jury how you're employed.
As a police officer by the city of Manchester.
How long have you been a police officer in Manchester?
I've been with Manchester for 16 years, and I had 4 years prior experience before I came here.
Are you a certified police officer in the state of New Hampshire?
Yes.
Where is the Manchester Police Department located?
It's 351 Chestnut Street. It's actually across from the front of this building.
And what county is that in?
Hillsborough.
Can you please describe for the jury what your duties and responsibilities are as a sergeant for the Manchester Police Department?
Sure. My duties are the same as any other police officers. My responsibilities as a sergeant is to supervise patrolmen during the course of their shift.
Were you working for the Manchester Police Department back on June 4th, 2011?
Yes.
Do you remember what shift you were working that day?
4 to 12.
Do you remember what you were wearing that day?
This uniform. It's called the uniform of the day. It's just short sleeves for the summer weather.
Is there also a hat that you wear with it?
Yes.
Were you wearing a hat on that day, do you remember?
No, I was not.
So just the uniform that you have on now?
Yes.
Can you please tell the jury what was happening outside the police station that day? Just a brief overview.
There was a group of maybe 15 to 20 people who were protesting some of our police activities outside of the police department. They were writing on the building, the exterior of the police department, and the surrounding. We have a retaining wall that's up in front of the police station. They were writing slogans up on the building with chalk.
Was that also on the sidewalk and retaining wall as well?
Yes.
Was this considered a crime?
Yes, it was.
And what, as a result of it being a crime, was there anything done to preserve the evidence or the markings that were made on the walls and the sidewalk?
Sure. There were, prior to what we would consider the collection of some evidence, there were a number of arrests that had been made. So in order to document what had occurred before the arrests, I had asked some detectives to come out and take photographs of the writings that had been written on the wall in the surrounding area.
And were they doing that? Were they taking photos?
Yes.
And did you see the officers taking the photographs?
Yes.
And while the officers were, they're actually detectives, is that right?
Yes.
While the detectives were taking photographs, what was occurring at that time?
A number of the people in this group were still in the area, still around, on the sidewalk in front of the police department.
Now, while you were outside, did you have contact with a person by the name of Catherine Ager?
Yes, I did.
Do you see her here in the courtroom today?
Yes, at the defense table in the black dress.
And please let the record reflect the witness identified the defendant.
Yes.
And can you please explain for the jury how you came in contact with her on June 4th, 2011?
As the detectives were beginning to photograph the area, and if I can use this as a front, the police station would be here, Chestnut Street is in front, so they would have to come around from the side of the building and then begin northerly.
Your Honor, I'm sorry, may I stop for a moment? Is it okay if he uses that board over there
Certainly.
to show that to the jury?
It's heavy.
I'll let him look there.
Yeah, Ms. Sager, you can stand over here so you can see the drawing.
And actually, would you mind just putting it down a little bit this way, and a little out so the judge can see this?
It's more important the jury see it than I see it.
Thank you. So if you could just draw the police department and where you were just talking about.
We'll call that the police station.
You want to stand on the other side, Ms. Sager? The officer's standing over here. Why don't you move over to the other side and you can be able to see it more easily. You're going to block the jury. You got to go back a little bit.
There you go.
There you go. Jurors all see now? Okay.
Okay, thanks. All right, this should do for now. So, Chestnut Street's here, the sidewalk, the front door is the police station here, we also have a side door. Now, in front of the police station is a retaining wall, so the detectives were photographing graffiti that had been written on the building here, along the sidewalks, along the retaining wall, and then they were going to walk northerly up here and continue photographing everything that had been written.
Would you mind just writing the date and the initials down at the bottom? So when you come out of the police department, where are you?
I came out, I was in and out a few times during the course of events, but came out of the steps down onto the Merrimack Street side.
Is this when you had contact with the defendant?
Yeah, she was.
Could you please place next? If you can, I know it's only an estimate.
Yep. She was standing here.
Okay. And can you put a P for Sergeant Patty where you were standing? When you first came in contact with her?
Well, the course of events that we're going to be speaking of mostly occurred right here.
And where's the courthouse and all this so people can have some sort of relation of where this is?
Right here. So who you guys are.
Okay. Your Honor, at this time, the state is just going to ask that this be marked into evidence.
Any objection?
No.
Marked as states 1?
I believe it states 3.
Oh, so there are other, I'm sorry, there are other pre-marked exhibits, states 3. Sager, can you see Sergeant Patty, or is this in your way? Yeah, why don't we move this? I think it's right in her sight line. Just put it back there.
So could you finish explaining how you came into contact with the defendant outside the police department?
Sure. As the detectives were going to be walking onto Chestnut Street in the beginning northerly, she was standing where that X is, and I told her she was going to need to move because we were going to be taking photographs.
And did she move when you asked her to?
No, she didn't.
What did she do?
She began to ask questions about why she couldn't be there. I told her that there was evidence of a crime that we were going to be investigating, and she said something to the effect of, it's just chalk. I can't, it's on a public sidewalk, things to that nature.
And was that, and I'm sorry, you testified earlier that that was in fact a crime?
Yeah, the graffiti that was posted on the wall is a violation of city ordinance and also a violation of state criminal code for criminal mischief.
So after the defendant didn't move after you requested her to move, what happened?
I told her again that if she didn't move, I was giving her a lawful order to move. If she didn't, she could be arrested.
And then what happened?
She still didn't move. She wanted to ask me questions. At that time, I told her no, and I told her she was under arrest.
And what did you do?
As I went to grab onto her wrist to place her under arrest, she pulled away from me, and we began to struggle. I say we because there were other officers there as well. We began to struggle with her. She was placed onto the ground and handcuffed.
And who else assisted you in handcuffing the defendant?
Sergeant Muchi and Officer Elston.
While you all three of you were involved in trying to handcuff her, was she still struggling?
Yes.
Now, you had mentioned that there were a number of officers there. How many officers do you think were out there that day?
We probably had close to 10 police officers, I would say.
And how come so many?
Well, the protest as it was occurring, first of all, they were writing on our building, which obviously, aside from being a crime, we took offense to. Part of the things that they were protesting was fine. They have a message that they wanted to get out, and that's fine. But we still have business that we need to conduct there. A lot of times they were blocking the sidewalks, so they were told a number of times that if they were going to be out in front of the building, they had to be moving. That's part of the city ordinance, that you can be out there, you just can't be standing still in one spot. A lot of the times, or after the initial arrests were made, that's when we had to come out and photograph the graffiti that was on the building. And there was still probably 15 to 20 of them. So for the most part, their protest was peaceful, but we still can't take that for granted, so we have extra policemen out there in case there are problems.
So for safety purposes?
Yeah, safety purposes, crowd control. Like I said, we still have other business to conduct. Other people still want to come into the building.
Prior to coming in today, did you have the opportunity to review 2 videos?
Yes, I did.
Your Honor, at this time, the state is going to ask to play each of the videos separately for the jury. if that's
Okay. Yes, I understand. They're by agreement. Correct, Attorney
Yes.
Yeager? Yes. Thanks.
Is there any way to?
Yeah, we will.
As soon
We
as you
will.
put
As
it
soon
on
as
the-
you will. But we can't dim the daylight. That's the skylight can't be dimmed.
Now, when you reviewed this video, was it a fair and accurate representation of what occurred that day?
Yes, for the most part.
Did these videos encompass everything that occurred?
No.
So it's only part of what had occurred?
Yes.
Did it cover your complete interaction with the defendant,
Most of it.
but not all of it?
Right.
And I'm playing what is States 1 first. Officer, is there anything that you can point out in here of like where you are or anything like that while this is playing?
I believe I had just walked past her. The shadow that you see right there in front of is, I believe, her filming from her cell phone. In the background, you can see, well, maybe you can't see, there you go, there's a detective right there coming with the camera.
Is that the one in plain clothes?
Yes, there are two plainclothes detectives.
Get off the chalk. I'm standing on the sidewalk. How is Ray?
This is your last chance.
No, I'm just telling you that how is Ray?
We're ready to leave because we have to take pictures.
How is writing on the side?
So that was you asking the defendant to move?
Yes.
I'll show you what has now been marked as States 2.
Can you grab the camera out of my lap?
Is that the defendant right there?
Yes. Yeah, in the pink sweater.
And who are the other officers with you right there?
Sergeant Muchi and Officer Elston.
And are those the people you're talking about that were outside the police department that day?
Those were a portion of them, yeah. Like I said, until that point, there'd already been a few arrests. That were
And which one is the defendant?
in the pink sweater.
Now, at the beginning of this video, are you able to see that the defendant is actually struggling with you and the other officers?
Yes.
I'm just going to replay it in a minute and actually have you point that out to the jury if that's okay, because it's a little hard to see.
See, she's falling down like that, trying to wiggle her arms around.
Do something with it.
And then that's when the other the other two officers had stepped in.
Yes.
Thank you. Is there any doubt in your mind that the defendant was struggling with you and the other officers that day as you were attempting to arrest her?
No.
No further questions at this time, Judge?
You may cross-examine.
So, Sergeant Patty, you keep referring to a group of protesters as if I was part of the group as opposed to just an individual who happened to be in the area at the time. Is that correct? Is there a reason that you feel that I was part of a group as opposed to just an individual?
No, I testified that there were a group of people protesting in front of the police station.
Okay. So you stated that after you said it's the scene of a crime, I responded by saying it's just chalk, correct?
I believe so. I mean, I wasn't paying particular attention to that part, but I remember that comment.
That's what you just testified to.
Yeah, there was, again, I don't know your response to, my
Okay.
statement to you, but
Okay, well, you did just testify that I was saying it's just chalk, when in reality I was asking how is, and you never heard the end of my question because you began to talk over me, correct?
okay, yes.
Okay. So, the testimony about what I said was inaccurate?
Well, no, it's, accurate as to what's on the tape there. Again, there was mention of chalk, how can this be a crime? It's just chalk.
All right, I don't recall saying it's just chalk anywhere in that video. If you
Objection,
would-
Your Honor.
Sustained.
Okay, can you?
You understand, Ms. Negro, you can't
Okay.
testify. You have to
Yes.
ask the
Yes,
officer.
I am going to rephrase that as a
Okay.
question.
Okay.
I apologize. If I play the video, could you please point out where I say that?
Sure.
We're in the second video? Or the first video? Which video do you want to play?
This is the first video.
First video.
Is the jury able to hear the audio recordings?
You should turn your audio up as loud as it'll go.
Okay. I was just going to bring the microphone over.
Oh, you can do that too. If you bring this mic over, it will amplify the video. Just drop the mic down. You can actually drop it lower.
Okay.
You had this problem once before. Thank you, Karen. Hold it for 1 second.
chalk?
Yeah, 10 minutes. Evidence.
I'm standing on the sidewalk.
No, I'm asking you to listen. Evidence of a crime. We have to take
How is, how,
Listen, this is your last chance.
I'm
You
just,
don't need to ask me. I'm telling
I
you.
have a question.
I don't
How
have to
is-
do that.
how is
Give me
writing-
a lawful order. Leave because we have to take pictures of this. If
How
you
is-
don't wanna move,
I was riding on the sidewalk.
you're under arrest.
Get off! So can you please describe where in the video I was saying it's just chalk?
Well, it was the first thing out of your mouth, something about chalk.
Is it correct that I said in the form of a question, get off the chalk, with inflection at the end? Did that
You know,
appear to
if-
be a question to you?
It may have been.
So you claim that I struggled when you were attempting to arrest me.
Yes.
Could you please describe how I struggled?
Yeah, I went to grab your wrist and you pulled your wrist away.
Okay. So you stated that I was falling down and trying to wiggle my arms away as that was happening as part of the struggle?
Yeah, in the second part of the video, yes.
Yes. Okay. I would like to play the second video. But before it starts, I would like to ask you if you would watch and see if it appears that I am falling down and trying to wiggle my arms away, or if I am falling down and my arms are being held back by you and another officer.
Okay.
Can you grab the camera out of my lap and do something with it?
Okay. Did you notice whether it appeared that I was falling to the ground and trying to pull my arms away at the same time, or if I was falling to the ground and being slowly lowered by you and another officer?
Yeah, as I testified to before, you were placed on the ground, so yeah, as I went to grab you and you pulled away, other officers stepped in and you were struggling, because that's why your hands are behind your back, because I had grabbed on for you to put your hands behind your back, and you were struggling to get away, and we lowered you to the ground.
Was I attempting to run, or, was I attempting to run away from you?
No.
Was I attempting to use force to stop you from arresting me?
Yes.
Okay. How long did I delay the arrest?
That was one continuous moment in time.
I delayed the arrest for one continuous moment in time.
No, the arrest is one continuous moment. The fact that you're resisting and struggling is all part of the arrest.
Okay, at a previous hearing, you stated that I delayed the arrest by 1 second. Is that accurate?
I don't. My recollection of that is that we were talking about the time before you were placed under arrest.
That is not accurate.
That's my memory.
Okay, so you do not recall saying that I delayed the arrest by 1 second?
Again, I remember in another hearing, we talked about the time lapse between you were told you were under arrest and the time that you were physically engaged in the arrest.
Okay. At the previous hearing, you testified that when I struggled was during the 3 or so seconds between the first video ending and the second video beginning. how is it that now the struggling has magically appeared on video?
I don't understand that question.
Last time that we had a hearing, you testified that when I struggled, it was not caught on video. It was in the 3 seconds or so between the first video ending and the second video beginning that I struggled.
No, my memory of that is you asked about what happened from the time that I grabbed your wrist. And if you notice on the first video, as soon as I go to grab your wrist, the phone tilts sideways and then it goes white or blank. And then somebody filming, actually from right outside of this building, caught this part.
So you just testified that I was still struggling while you were, while I was on the ground and you were trying to put handcuffs on.
Yes.
I would like you to please show where I am struggling while I'm lying on the ground, okay?
Could you grab the camera out of my lap and do something with it?
Okay, that little box may have just covered me in the video, so I'd like to try that one more time. Just-
Why don't you move it up in the top left? I think that'll be good.
Could you grab the camera out of my lap and do something with it?
While I'm lying on the ground, do I appear to be struggling in this video? Or could you please point out where in this video I am struggling when I'm on the ground?
Yeah, you were, because actually I remember having trouble handcuffing you because of your sweater. We couldn't get the handcuffs. When you were trying to move your arms apart, your sweater was caught in between the, not the hinge, part of the hinge of the handcuff.
Okay, so you had difficulty putting handcuffs on because of my sweater?
That was part of it, because of
Okay.
you wiggling your arms. Yes.
Okay. Can you see me wiggling around when I'm on the ground in this video, or do I appear to be laying still?
Well, you were not laying still, you were on your side, and the officers that are in front of you are blocking, the angle a little bit.
Okay, so you cannot see in this video me wiggling my arms around or moving while I'm on the ground, other than a slight twitch of my leg because there's people on top of me.
Well, I'm testifying that I remember us having trouble because of you moving your arms and the sweater, but
I am currently asking about the video, not your recollection. The video specifically, you said that you could see it in the video, me struggling while I was on the ground. Could you please point out where in this video, when I'm on the ground, I'm struggling?
well, I guess, on the ground, that's why there were 3 officers on you, trying to handcuff you. So, whether or not I can see you or not on this video, I guess I'll let the video speak for itself.
Okay, so you cannot point out a place in the video when I'm on the ground that I'm struggling, is that correct?
You know what, if we want to watch again and we'll go through it,
Okay.
that's fine.
Could you grab the camera out
Right
of my
there, yeah,
lap
you were struggling, right there,
and
you're
do
struggling
something
the other way.
with it?
So I was struggling when I was on my knees with my arms up behind me.
Yes.
Alright, how was I struggling right there?
Well, the way, the standard for an arrest is if you're asked by an officer to submit to arrest, then you have to comply with the order. Any type of resistance, whether it be passive or physical, trying to blow away, you don't have to be running.
Excuse me, that is not what I was asking you.
Your Honor, I believe he's answering the question.
I don't believe that that is the answer to the question. I was asking how I was struggling right at that moment. I was not asking about the like what you need to do when
I'll just,
you're arrested.
I'll overrule the objection. He can answer. Restate your question, Ms. Ager.
Okay. When I was on my knees with my arms up behind me, where you just stated that I was struggling in that video, could you please describe how it was that I was struggling in that specific?
Yes, you were trying to pull your arms away.
Okay. How could I try to pull my arms away if they're being held behind me and I'm on the ground? Was I trying to pull them towards the ground? Or was I trying, like, could you describe that?
Yeah, I can't speak for what your intentions were, but yes, you were trying to pull them away to prevent us from being able to handcuff you.
What is your reason for believing that I was trying to prevent you and other officers from handcuffing me?
Because when I went to grab onto her wrist, she pulled her hand away, and then during the course of trying to arrest her, she was physically trying to pull her arms away from us, which is, in my experience, standard and typical for when people don't want to be arrested. Their normal reaction is to pull them away from us and eventually hold them to their chest.
Did I, at any time, try to hold my arms to my chest?
Well, you didn't have the opportunity.
Okay.
So
But you
the answer is
believe
no.
that that's what I was trying to do?
In my experience, yes, when people resist, they try and pull their arms away and get into a position of more strength for them.
In your experience, when people try to resist, do they generally fall to the ground when they're surrounded by 10 police officers, or would they generally try to get away from the people that they're trying to resist?
I'm sorry, resistance can take the form of anything, except for verbal protests. Any type of physical arrest can be, what you saw here, somebody running away, somebody kicking us, punching us. It can take any form.
Were you ever in fear of great bodily harm from me?
No,
Were you in fear of great bodily harm for your colleagues?
no.
Nothing further, please.
Thank you, Judge. Mr. Dunn.
May this witness be excused? Judge, may this witness be excused?
Oh, yeah.
The state is going to call Sergeant Joseph Muchi to the stand next, Judge. I'm just going to shut this video off and see how it goes.
Here.
I'll keep it right. You can just go right around.
Here. No, the other one here.
Do you swear affirm the testimony about to give the truth, the whole truth, and nothing but the truth under pains and penalties of perjury?
I do.
Please have a seat.
Good morning.
Could you please introduce yourself to the jury, spelling your last name?
My name is Joseph Muchi, and I'm CCI.
What is your occupation?
I'm a police officer here with the city of Manchester.
Are you a certified police officer in the state of New Hampshire?
I am.
How long have you been with the Manchester Police Department?
15 years.
Can you please describe for the jury what your duties and responsibilities are as a sergeant of the Manchester Police Department?
Yes, I'm currently a patrol sergeant. I work 4 to 12. I supervise 10 patrolmen within Sector 2. The city's separated into different sectors. I'm also the SWAT team leader, so I supervise 20 officers on the SWAT team as well.
Were you working for the Manchester Police Department back on June 4th, 2011?
Yes.
Were you working the same shift you just told us about, 4 to midnight?
Yeah, my hours are 2:30 to 10:30, but it's considered, yes, 4 to midnight.
Okay. What were you wearing on that day?
I was dressed in a full police summer patrol uniform, so short sleeve police shirt, pants, full duty belt, radio.
Can you please tell the jury what happened on June 4th at about 4:45?
I was returning to the station after making an arrest and was turning onto Chestnut Street when I observed a group of people out in front of the police department writing slogans and words on the sidewalk, the retaining wall in front of the police department, as well as our building.
And we have a diagram right there that Sergeant Patty did for us. It states Exhibit 3. Would you mind coming down and looking at that and telling us where it was when you pulled up? Were you in your cruiser at the time?
I was, yes, a
Okay.
fully marked police supervisor's cruiser.
Can you please tell the jury where you...
One moment, we gotta move mics. Can you move that mic back?
Thank you. Can you tell the jury...
We don't need it to amplify, officer, just, it'll pick up for the record.
Okay, I just wanted,
And can you please explain to the jury where it was that when you first pulled up that you first saw these the protesters outside the police department?
well, it's not in this actual diagram, but there's an alley that runs, this would be Manchester Street. There's an alley that is north of Manchester Street, and we typically come down that alley, which would be westerly, and then turn southerly on Chestnut Street, and then back onto Manchester Street before pulling into the actual west.
And where was it that you were seeing that the people protested?
They were in front of the PD. They were in this area here.
Okay. And from your position, did you say that you were able to see writings on the wall and stuff?
I couldn't see the writing at that point in time, but I could see that they were actually writing on the sidewalk, on the building, and on the retaining wall. It wasn't until I was actually stopped in front of the building that I saw what was being written.
And how many people would you say that there were?
10 to 15.
And so what did you do after you saw these people outside the police department?
I notified dispatch of what I had seen. I actually went around the block and then I stopped somewhere in here, parked my cruiser, and that's when I was actually able to observe that they were writing in colored chalk on the sidewalk, the retaining wall, as well as the building.
And is that a crime?
It is.
And you can have a seat, thank you.
You need justice.
That's fine, thank you. Attorney York, would you pull that mic in front of the podium, only because the record doesn't pick you up otherwise? Thank you.
So what did you do after you saw this, Sergeant?
We made a number of arrests at that point in time, and after the arrests were made, went back into the police station to process these people that were arrested.
And at some point, did you come back outside?
I did.
And at that time, did you have contact with a person by the name of Catherine Anker?
I did.
And do you see that person here in the courtroom today?
I do. She's sitting at the defense table wearing the black sweater.
Can I please let the record reflect the witness identified the defendant?
It does.
Can you please explain to the jury what interaction you had with the defendant on that day and what you saw happen?
Yes. We had returned outside at that point in time to actually document the evidence of the people that were there that were writing on the, as I told you already, the sidewalk, the building, and the retaining wall. So detectives had come outside with us to photograph the evidence. So that's when we went outside to actually begin photographing from Merrimack Street towards Manchester Street. And that's when my interaction with the defendant began.
And can you please tell us about that interaction?
She was actually standing on some of the writing that was on the sidewalk and in front of the wall. If you look at the wall at the corner of Merrimack and Chestnut, it's angled, so there was writing on the wall and on the actual sidewalk. So she was blocking the wall and the sidewalk, at which point she was asked, I believe, at least twice to move so we could document this evidence.
And did you hear that? Did you actually hear her being asked to move?
Oh yes, I was right next to Sergeant Patty,
And you heard him ask for that?
twice.
And did you see whether or not she complied with his order to move?
No, she refused to comply. All she wanted to do was get her point across. Regardless of what her point may be, when a police officer gives you an order, whether to move or not, you're required as a citizen to do so. She refused to comply at that point.
So when she didn't comply with Sergeant Patty's request to move, what happened?
She was placed under arrest.
And did she submit to that arrest?
No, she did not.
Can you explain to the jury?
She began to yell and scream, excuse my language, but she yelled, "Get the fuck off me." Started to pull her hands away from us, and at one point, she starts to passively resist, so she lets all her weight come to us, so she's not cooperating, she's interfering with us, trying to make an arrest. So in order to protect her, we allowed her to go to the ground, and that's when we were able to place handcuffs on her.
Now, you keep saying we. Who are you talking about?
Sergeant Patty and I, and there was some other officers there as well at that
Okay.
point in time, but it was Sergeant Patty and I directly.
Was Officer Elston also assisting in the handcuffing of the defendant along
Yes.
with you and Sergeant Patty?
He was.
Before coming in here, did you have the opportunity to review some videos?
I did,
Okay. And were those videos fair and accurate of what occurred on that day on June 4th?
yes.
And I'm just going to show you one of those right now. And if you can maybe point out where you are in this video if possible, that'd be
Okay.
fantastic.
We're looking at Exhibit 1 or 2.
We are going to be looking at Exhibit 2, Judge.
Would you like me to approach or stay here?
No, you should be able to, are you able to see right here? It's right, it's, okay.
Can you grab the camera out of my lap and do something with it?
Now we see, we saw 3 officers down with the defendant. Are you one of those officers?
Yes, I am.
Okay, and who are the other 2?
Sergeant Patty and Officer Elston.
Okay. And you were just telling the jury about the struggling stuff. Were you able to see that in this video?
It's hard to because being blocked somewhat by the officers that are there, but that's when she begins to passively resist. We take all her weight, we bring her to the ground to protect her.
Okay, and is she struggling as you guys are
Yes.
lowering her to the ground? While you guys are attempting to arrest the defendant, are you or do you hear anybody else giving her commands to stop resisting her?
Yeah, we're telling her to stop resisting when that occurs.
And did she stop resisting?
No, we had to actually force the handcuffs on her.
Any further, Judge?
Cross-examine.
So, Sergeant Muchi, you say that when Sergeant Patty asked me to move, I refused and was more worried about getting my point across, correct?
Yes,
Okay. Is asking a question trying to get a point across?
yes.
What point is asking a question trying to get across?
Whatever your point was that you were making, that you refused to move after you were given 2 lawful orders, you can certainly tell the jury that you decided to testify. So I can't tell you what was in your head at that point in time, but you didn't comply with 2 lawful orders, so that's why you were placed under arrest.
Let me just caution members of the jury that Ms. Agar does not have to testify. That's entirely within her rights, and you may not draw no inferences whatsoever if she chooses not to testify. And you should disregard the officer's testimony on commenting on whether she chooses to testify or not. That is her absolute right not to testify, and you may not draw any conclusions if she decides not to do so.
So, could you please explain how asking a question is getting a point across?
Yeah, I believe that was just asked and answered.
Move on, please.
Okay. So, you say that I struggled and tried to pull my arms away when you and Sergeant Patty attempted to arrest me?
Yes,
Okay. And then you stated that I passively resisted?
yes.
Could you please explain what passively resisting means?
Well, you necessarily weren't fighting, punching, kicking, that would be considered to be violent. Passively, you were pulling your hands away from us and then eventually released all your weight onto us and we had to hold you and bring you down to the ground. And you can see that in the video at some point as well. So you were interfering with us trying to make a lawful arrest, and when you interfere in a lawful arrest, then that would be considered resisting.
Okay, so you claim that
Let me give another cautionary instruction over to the jury. The jury will decide whether or not Ms. Agar resisted. That's a decision for you ultimately to make. I'll instruct you on the law, and you will decide whether the facts that you find were proved beyond a reasonable doubt do or do not constitute the offense charged. So the court will instruct you on the law.
So you believe that I purposely attempted to fall to the ground?
Yes.
Okay.
At one point, yes.
So is it reasonable to believe that the way that I was turned by Sergeant Patty could have caused me to lose balance?
I don't remember you being turned. I don't know what you're referring to as you being turned.
I'm referring, can I state what I'm referring to?
Only if it's in the video, Ms. Agar.
It is in the video.
May I ask questions about what's in the video?
Okay, I was just asking if I could state what I was referring to. So
In the video, yes, you may.
okay. I am referring to when Sergeant Patty initially reached out and grabbed my arm, and then as you can see in the video, he moves his left hand upwards towards my shoulder. And you can't see that I was turned, but at that point he did turn me, so I'm referring to then.
Your Honor, I guess I object because she is testifying.
Sustained. Whether Ms. Agar was or was not turned is a question for you to decide, members of the jury, from the evidence that's introduced here today.
Okay, is it reasonable to believe that when somebody is forcefully turned around that they may lose balance if they were not expecting to be turned?
Your Honor, I guess this calls for speculation.
I'll allow the question if you can answer it.
Can you repeat the question?
Is it reasonable to believe that if somebody is turned without, or forcefully turned without expecting it, that they may lose balance?
I guess it would determine on how forcefully you were turned, so I can't testify to that. I don't know.
But it is possible, correct?
I don't know without knowing how forcefully you say you were turned. I can't answer that.
Is it possible that somebody could lose balance when they are turned?
Ms. Agar, move on. He's answered this question to the best of his ability.
Okay. So you said that as I was falling to the ground, I was passively resisting. And you also stated that I was struggling at the same time. Can you please explain how I can be passively resisting and physically struggling at the exact same time?
Well, it was at two different times. When you were yelling, "Get the fuck off me," and we went to grab you, you pulled your hands away from us. So there, you're struggling. You pulled your hands away from us. Once we held on to you, you can see at some point that you have your knees up and we're holding your weight. That would be considered passive resisting. So in order to control you so you don't fall down and get hurt, we bring you to the ground, and then you're handcuffed, and then you were actually almost carried into the police department. So,
I'd like to show the video,
You
or
may.
at least a portion of the video. So you would describe my willingly walking up the stairs and to the doors of the police department as almost being carried in?
No, not that portion, prior to where it started, where you were actually, knees were limp and the officers were supporting you, and the part where I was actually holding you up before I passed you off to the other police officer, that part wasn't shown. That part you did walk in, yes, absolutely.
Okay, you stated that I was almost carried into the police department, so I just wanted to point out so when you said I was almost carried into the police department, you mean I was lifted to my feet?
Yes.
And then I walked into the police department, correct?
You walked in at that point, yes,
Okay.
but prior to,
Okay, thank you. Now, you did testify that I passively resisted as I was falling and I was trying to pull my arms away at the same time. So, as I already asked this, but I would like to ask again, how is that possible? Because you did say that there were 2 different times, but previously, when you were being directly examined, you stated that I did both while I was falling to the ground.
No, I believe you already answered that.
Sustained.
But I don't understand how he can change what he was saying.
Ms. Hager, what I've ruled on is, the objection is that he's already answered the question. I ruled that he has, so he doesn't have to answer it again. You can ask your next question now.
Did I attempt to run away from you?
no, you did not.
Did I attempt to use force against you or your colleagues? Like, such as hitting or kicking or biting or anything of the sort?
None of those actions, no.
Okay. Were you ever in fear of great bodily harm from me?
Not necessarily, but if you had hit me, it certainly could have happened, but
Okay. Were you ever in fear of great bodily harm from me against your colleagues?
again, if you had attempted to assault us, yes, but I already testified that you didn't.
How long did I delay the arrest?
I can't say for sure, maybe 4 or 5 seconds after both lawful orders.
Okay. More questions?
Nothing further, Judge.
Thank you, I step down.
Today is going to call Officer Clifford Elston to the stand. Thank you. Just up and to the right around. Okay. Please raise your right hand. Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth under pains and penalty of perjury?
I do.
Please have a seat.
Thank you.
Could you please introduce yourself to the jury, spelling your last name?
Yep, Officer Clifford Elston, E-L-L-S-T-O-N.
Could you tell the jury what your occupation is?
I'm a police officer with the Manchester Police Department.
How long have you been a police officer?
About 4 years.
Are you a certified police officer in the state of New Hampshire?
Yes, I am.
Can you please describe for the jury what your duties and responsibilities as a police officer with the Manchester Police Department encompass?
Yeah, I patrol my assigned area, whatever that may be for the day, in my fully marked cruiser, typically wearing the full uniform of the day.
And when you say the full uniform of the day, is that what you're wearing today?
Yep, it's very similar to this.
Were you working for the Manchester Police Department on June 4th, 2011?
I was.
Do you remember what shift you were working?
I was working 4 to 12s.
And what were you wearing on that day?
Outfit similar to this, if not the exact one.
So was it pretty clear that you were a police officer?
Very clear.
Can you please tell the jury what happened on June 4th at about 4:45 p.m.?
I was in headquarters. I was approached by shift supervisors. Was informed that there was a large gathering of individuals outside with the facing walls of the police department.
Okay. And so what was your involvement in that?
I went outside to assist with the evidence gathering, photographs, etc.
Okay. While outside, did you have contact with a person by the name of Catherine Ager?
I did.
Can you please point her out by describing something that she's wearing?
Yeah, she's wearing the black sweater with the light shirt underneath.
Can you please let the record reflect the witness identified the defendant?
Does.
Can you please tell the jury about your interaction with the defendant on that day?
When detectives first attempted to gather photographs of the chalk or graffiti, they first attempted to take photographs of the corner at Chestnut and Merrimack, and that is where Miss Ager was standing at the time.
Officer, if you don't mind, I might have you come down and look at State's Exhibit 3, which is the diagram on that board.
Yep.
Is that a fair and accurate representation of how the layout is?
Why don't you come over to this side, officer, because you're
Yes.
blocking the jury's view. So, well, that's all right.
Is that a fair and accurate layout of the police department and the streets and all that stuff?
It is.
Okay. And when you first saw the defendant, where was she standing?
She was standing right at this corner right here.
Okay. Is that where the X is?
Yes, yes, ma'am.
Okay. You can't see.
Yep.
It's just gonna look that close.
Sorry. And can you please tell the jury what you heard and what you saw?
What I heard is, I heard Sergeant Muchi, Sergeant Patty, speaking with Miss Ager. They were asking her to move. I believe they asked her about twice. She physically, verbally refused to move. They then instructed her that she was going to be placed under arrest for refusal to comply with their commands.
And was she in fact arrested?
She was.
While she was being arrested, did she submit to that arrest?
Not initially, no.
Okay. And did you have a chance to review the videos in this case?
I did.
coming in here?
Yes.
I'm going to show you what has been marked as States 2. And in particular, we're just looking where you are as well in this video.
Yep.
If you could point that out to the jury. I'll just rewind it to the beginning.
Can you grab the camera out of my lap and do something
Would you like me
with
to
it?
narrate? Okay. I was the officer who took the cuffs out of the rear pocket and was placing her hands in her cuffs while she was being restrained by the sergeant.
So that's you.
Yeah, I was wearing black gloves, glasses.
Okay. So we can see three people right here. Do you mind? We can see the three people right here. You're saying you were one of these people right
Correct, yes.
Okay. As the defendant was being brought to the ground, was she struggling?
She was,
Okay.
yes.
And did you have to assist? You said you had to assist with Sergeant Patty and Sergeant Muchi in actually handcuffing the defendant?
I did. They had to restrain her hands while I applied the handcuffs.
Okay. And was she still struggling at that point?
Yes.
Nothing further at this time, Judge?
Cross-examine.
Officer Elston, so you were there when Sergeant Patty asked me to move, correct?
That is correct, yes.
And you stated that I verbally refused to move, is that also correct?
That is correct.
Did I state that I wouldn't move? Did I say something like, no, I will not move, or I have every right to be standing here?
I don't remember the exact words. I just remember you complaining about the commands given to you.
Okay, I would like to show you the first video, and if you could please point out where or what words exactly I used when I allegedly verbally refused to move.
And this is stage one.
get off the...
Evidence of a crime.
I'm standing up. Why?
No, I'm asking you to leave because it's evidence of a crime.
How is right?
You know,
I'm just
I'm telling
I have a question.
I don't have
How is writing?
a lawful order to leave because we have. So
How
if you
is
wanna move?
how is writing sidewalk?
Guys, you're under arrest.
Okay. So could you please point out where I verbally refused to move and what words exactly I used?
While you might not have said that you specifically refused to move, the fact that you're complaining and you were arguing with the officers while they were giving you commands and you were physically not moving, those coupled together, I would take that as a verbal refusal to move.
Do you consider trying to ask a question to be complaining?
When it's given as a lawful order, yes.
Is "excuse me, would you get off the chalk, please" a lawful order, or is that a polite question?
I believe it's one and the same.
It is a polite question and a lawful order?
Yes.
According to the English language, that is not even an order, correct? It is a question.
Objection.
It's the same.
Okay. So you stated that I struggled as I was being brought to the ground.
Correct.
Could you describe how I was struggling as I was being brought to the ground?
Yes, you allowed your knees to buckle, therefore allowing your body to collapse to the ground.
Okay, so was I trying to pull away as I was falling to the ground?
I remember you had your arms rigid, but I wouldn't describe it as pulling away, no.
Okay. So, you believe that I purposely collapsed to the ground?
Yes, ma'am.
Okay. Did you see when initially Sergeant Patty grabbed my arm and turned me? Did you view that?
I was there for that.
Okay. Is it reasonable to believe that when somebody grabs onto you and turns you unexpectedly, it could cause you to lose balance?
I assume that's a possibility.
Did I attempt to run away?
No, you didn't.
Did I use force against you, such as hitting or kicking or biting or anything of the sort?
You did not hit, kick, or bite, no.
Okay. Were you in fear of great bodily harm from me at any time?
It's always a possibility.
I don't think that answered my question. Were you in fear of me specifically? Did I do anything that caused you to be afraid that I would cause you great bodily harm?
When you collapse like that, and I have to take on your body weight, it always poses a pretty significant risk of injury to the officers.
Okay. Once I was on the ground, did I struggle or did I lay still as you handcuffed me?
Kept your arms rigid, I remember, but did not struggle any more than that. No.
Okay, so my arms were tense when I was lying on the ground, but I was not trying to pull them away or something.
Correct, yes.
No more questions, thank you.
So just briefly on redirect, when was the defendant struggling? When did you see her struggling?
I'm sorry?
When did you see her struggling with you and the other two officers?
When she was told that she was going to be placed under arrest.
And she was struggling with all three of you?
Correct, yes, ma'am.
Okay. And can you explain for the jury, what is your definition of struggling? Like, what do you mean by struggling?
That could be construed as passive aggressive resistance.
Well, I'm going to redirect you. What do you mean by struggling here?
Yes. Thank you. What do you mean by?
Passive resistance.
Okay, explain that to the jury again.
Uh,
What was the defendant doing to struggle?
The buckling of the knees, the fact that, she wasn't just readily available, placing her arms behind her back, allowing us to properly cover.
So you're saying that she wasn't just giving you got her arms to be able to handcuff her behind or anything like that?
Yes, ma'am.
Nothing further, Judge.
You're entitled to ask questions in response to what she just elicited if you'd like. You don't have to, but you're entitled to. No more questions? You may sit down.
Thank you.
No, that's going to be the state's case for this case, Your Honor.
All right, it's noon. We'll break for lunch, ladies and gentlemen of the jury. Break for an hour. We'll resume at 1 o'clock. As you know, you're not to discuss the case with one another, to engage in any independent research, either actual or virtual. We'll see you back here at 1 o'clock.
All rise. Thank you.
Yeah. Would both of you approach, please?
You will either close and argue, or you can testify. It's up to you to decide. But you can let me know 1 o'clock what you want to do.
Okay, but, should be back here at 12:45?
Yeah, I'll give you a copy of the instructions, so you can look them over before. I always give the parties the opportunity to those instructions before they close.
And there's a specific instruction on the fact that they don't testify as well. Okay.
Right. Which I've already given the ones that I
Yes.
yeah. Okay.
Is the courtroom going to be locked so I can on my computer?
Yeah, we'll lock it. You can leave everything.
Great.
Please be seated.
I understand the defense rests. Is that correct, Ms. Agar?
Yes.
Closing arguments, Ms. Agar.
Throughout the course of this trial, you've seen 2 videos and heard testimony from 3 different police officers. The testimony of the 3 police officers had parts that were conflicting, such as Sergeant Patty and Muchi stated that I pulled my arms away and purposely collapsed to the ground, and did not recall that I was turned by Patty when he initially grabbed me. Elston did not testify that I was pulling my arms away, and confirmed that I was turned by Patty. He also testified that I was not pulling away or struggling on the way to the ground, or while on the ground, as Patty and Muchi claimed. The evidence shows that Patty reached for my arm and shoulder, and then pictures me mid-fall on the way to the ground. In the video, there is no scene that can obviously and clearly be determined as struggling or resisting. Muchi stated that I delayed the arrest maybe 4 or 5 seconds, yet there is no 4 or 5 second clip of struggling. You have heard different interpretations of what happened, or what, based on the evidence, could reasonably be believed to have happened. I ask that you consider the evidence presented to you and find me not guilty based on lack of proof and, quite simply, that I did not resist arrest. Thank you.
Attorney Dulac.
Thank you, Your Honor. Good afternoon, ladies and gentlemen of the jury. As you heard all 3 officers testify, the defendant was struggling with him. And when you see that video, and you can take that video back with you to the deliberations, look at that video closely, and you will see that the defendant was struggling with them. All three testified that she was struggling when they were trying to handcuff her. It took 3 police officers to handcuff the defendant because she wouldn't submit to the arrest, which is the law. I'm going to show you that video once more in here, but as I said, you'll have this in the jury deliberation room if you want to review it again. But pay close attention. This is the second video, which is the far away shot that was taken from somebody that was standing in front of the courthouse. And you will clearly see that the defendant is struggling on the way down. She's moving on the way down. She's struggling. She's not submitting to the arrest. If she was submitting, it wouldn't take 3 officers to handcuff her.
Is that podium?
Oh, maybe.
Is that in the
Can you,
way?
is podium blocking anyone's
Is this
view?
blocking your view?
Can you grab the camera out of your lap and do something with it?
You can see her arms are struggling right here. She should get down to the ground.
I'm sorry. When last time,
As you saw, and again, you can see that in the jury deliberation rooms if you want to view this again, she's struggling. She's saying, "Get the fuck off of me." You heard that clearly in the first video. "Get the fuck off me." That's not somebody who's submitting to arrest. She's not, and you heard that from the 3 officers. Now, as I told you at the beginning, the state needs to prove to you certain elements beyond a reasonable doubt. There's 4 of them, which the judge is going to instruct you on at the close of the closing arguments. First is that the defendant acted knowingly, meaning she was aware of her actions. It's pretty clear from the video that she knew what she was doing. She made a choice that day, and it wasn't to follow the lawful order of Sergeant Patty. She wanted to argue with him. She didn't want to move. And she didn't move after she was told to by a police officer. That she physically interfered with another person, that being Sergeant Patty, Sergeant Muchi, and Officer Elston. You heard from the officers, again, she was struggling. She wasn't submitting. If she was, it wouldn't take 3 officers to handcuff her. She was resisting, physically resisting. She doesn't have to kick, she doesn't have to bite, she doesn't have to hit to be considered resisting arrest. That's not the law. And it doesn't matter how long that she struggled for. The fact of the matter is she did struggle. Doesn't matter if it was 1 second, doesn't matter if it was 5 minutes, it's still resisting arrest. The third element is that she knew Sergeant Patty and Sergeant Muchi and Officer Elston were law enforcement officials. It's very clear from the video that they were police officers outside the Manchester Police Department. There should be no doubt in your mind the fact that she knew that they were police officers and that they were trying to arrest or detain her. As you heard on the video a number of times, Sergeant Patty clearly tells her, "You are under arrest. If you don't move, I'm going to have to arrest you. You are under arrest." And that's what he has to do. She knew she was being placed under arrest, and she didn't want to submit to that arrest. We are here because of the defendant's actions on June 4th, 2011. It is a crime to resist arrest. We are not here to decide whether what the defendant was doing was legitimate. You're not here to decide whether you agree or disagree with the Manchester Police Department and what they did. It is not for us to decide whether they are right or wrong. We are here to decide whether or not the defendant resisted arrest. That is the crime that she is charged with committing. The resisting law is in place for a reason. It's to help discourage self-help, provide for the safety of officers, and administer justice. Laws are written for a reason. Without them, what kind of chaos would there be if every time somebody disagreed with an arrest or a detention by a police officer that they could fight back and they could resist? What kind of danger would that impose on everybody, including the officers and the people around him, just because you disagree with the officer that you could resist arrest? Did she hit them that day? No, she didn't. But as you heard when the officers testified, I don't know what kind of harm, if she had decided to like hit or kick or anything like that. There's a reason to the resisting arrest law, and that is to prevent injury, discourage self-help, and administer justice. The defendant broke the law, and she committed this crime, ladies and gentlemen. At the start of this case, you took an oath. When you first walked through that door, you took the oath to listen to all the facts in this case, listen to all the testimony, and render a fair and just verdict. This case shouldn't be decided out of sympathy for one party or the other, but decided on the facts of this case and whether or not the state met and proved to you beyond a reasonable doubt all 4 elements of the resisting arrest crime. The state is asking that you uphold the law, that you follow the oath that you took when you walked through that door to render a just and fair verdict in this case. And when you do, the state is confident that you're going to find the defendant guilty of this charge. Thank you.
At this stage of the trial, it's my duty to instruct you on the principles of law that you must apply in deciding this case. You should not single out any one instruction, but instead apply these instructions as a whole to the evidence in this case. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definition of the crime with which the defendant is charged. You have to understand how convinced one way or the other you should be before you reach your verdict. And you have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I'm about to give you, regardless of any opinions you may have as to what the law is or the law ought to be. The law, as I give it to you in these instructions, is the law that you must follow in reaching your verdict. It is up to you to decide the facts of this case. You and you alone are the judges of the facts. You apply the facts as you find them to be to the law as I give it to you in these instructions, and in this way you reach your verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. Throughout the trial, I must be fair and impartial, just as you are required to be. Therefore, if I said or did anything during the trial that causes you to believe that I favor one party over the other, I now instruct you that I do not favor either party in this case. You and you alone, as I said, are the judges of the facts, and you decide the verdict. The role of the judge is to run the trial in a fair and orderly manner, to decide the admissibility of evidence, and to instruct you, the jury, on the law that applies to the case. Please do not place any emphasis on my note-taking during the trial, because, as I have explained, our roles are quite different. You are to decide the facts based only on the evidence, and the evidence in this case was the testimony under oath of the witnesses and any exhibits which were admitted into evidence. Those exhibits will go with you into the jury deliberation room. There are certain other matters that you may not consider as evidence. The fact that the defendant has been charged in a complaint is not evidence of her guilt. A complaint is simply a way of giving the defendant notice of the accusations against her. A complaint is a formal way of accusing her of a crime in order to bring her to trial, and you must not consider the complaint as evidence of guilt of the defendant. The possible punishment of the defendant if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge. You should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. A defendant, although accused, begins a trial with a clean slate, with no evidence against her. The law permits nothing but the admissible evidence presented before you to be considered in support of the charges against her. The law presumes every defendant to be innocent until proven guilty beyond a reasonable doubt. The burden of proof rests entirely on the state. A defendant does not have to present evidence or prove her innocence. A defendant enters the courtroom as an innocent person and is presumed innocent until the state convinces you beyond a reasonable doubt that she is guilty of every essential element of the offense charged. That presumption means that you are to regard the defendant in this case as innocent, unless the state proves beyond a reasonable doubt that she is guilty. A person accused of a crime has an absolute right not to take the stand to testify. The fact that the defendant did not testify must not be considered by you in any way in deciding this case. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. The defendant has no obligation to present any evidence or prove her innocence. As I explained in my initial instructions, what the prosecutor and the defendant say to you in their opening statements and closing arguments is not evidence. In their opening statements and their closing arguments, they attempt to help you understand the evidence from their point of view. But what they say to you in these arguments is not evidence in the case. If the prosecutor and/or the defendant have stated the law differently from the law as I explained it to you in these instructions, then you must disregard what they have said about the law and follow my instructions. Similarly, if during argument they have stated the facts differently from the way you recollect them to be, based upon your recollection of the testimony offered during the trial, then you should disregard what they have said about the facts and follow your own recollection. During the trial, the prosecutor and/or the defendant made objections. Litigants are supposed to object when they believe that certain evidence may not be admissible under our rules of evidence. Do not hold these objections against either party. Sometimes these objections require bench conferences. If I sustained an objection and I excluded any evidence, you must not guess as to what that evidence might have been. If I overruled an objection and allowed certain evidence to be admitted, you must not give that evidence any special weight as a result of my ruling. You should consider only the legally admissible evidence, in short, the testimony of witnesses under oath and the exhibits that were admitted into evidence. Now, there are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony or statement of a person about what the person saw, heard, or did. Circumstantial evidence is indirect evidence, that is, proof of a chain of facts from which you could find that another fact exists, although it has not been proved directly. As an example of direct and circumstantial, an example of direct and circumstantial evidence is always helpful. Assume, if you would, that you were about to go on vacation, and before you leave, you pass your neighbor's house, which is the color white. When you return from vacation, you notice that your neighbor's house is now the color brown. You use this color change as circumstantial evidence that while you were on vacation, someone painted your neighbor's house, even though you did not actually see it happen. If you had actually seen someone painting your neighbor's house, that would be direct evidence. You should feel free to reach reasonable conclusions from proven facts, but you may not reach conclusions on facts that have not been proved. You should consider both kinds of evidence. You are permitted to give equal weight to both, but it is for you to decide how much weight to give any evidence, whether it is direct or circumstantial. However, to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other rational conclusions. This means that if, from the circumstantial evidence, it is rational to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the rational conclusion consistent with innocence. However, do not consider each item of circumstantial evidence in isolation. In determining whether all other rational conclusions have been excluded, you should consider each item of circumstantial evidence in the context of all the other evidence, which includes all other circumstantial evidence and direct evidence. You should consider all the direct and circumstantial evidence in the case, as well as any reasonable inferences you draw from that evidence, in deciding whether the state has proved all the elements of the crime charged beyond a reasonable doubt. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses nor the quantity of the evidence that is important, but the quality of the evidence. That is, how satisfying and persuasive the evidence is to you. In deciding whether the state has proven the charges against against the defendant beyond a reasonable doubt, you must consider the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict and decide what the truth is. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. In deciding what witnesses to believe, you should use your common sense and judgment, and I suggest you consider a number of factors. The witness's age, intelligence, and experience, whether the witness appeared to be candid, whether the witness appeared worthy of belief, the accuracy of the witness's memory, the appearance and demeanor of the witness while testifying, whether the witness has an interest in the outcome of the case, whether the witness has any reason for not telling the truth, whether what the witness said seemed reasonable or probable, whether what the witness said seemed unreasonable or inconsistent with the other evidence in the case, and whether the witness had any friendship or animosity towards other people in the case. You should consider these factors in deciding the credibility of all witnesses, whether they happen to be ordinary citizens or police officers. In short, you should consider the testimony of each witness and give it the weight that you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It's up to you. In deciding whether to believe a witness and how much of his or her testimony to believe, you should consider both the direct and cross-examination of the witness. You need not believe a witness's testimony simply because it is uncontradicted. As I said, The determination of witness credibility is up to you. In deciding whether you believe a witness, you may consider whether the witness made statements before trial which were not consistent with what the witness said at trial. If the witness made an inconsistent statement before trial, you may use that statement in deciding whether to believe the witness. You may not use the statement made before trial as proof that the facts in the statement are true. The statement made before trial is only to be used by you in deciding whether to believe a witness. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss how convinced one way or the other you must be, and this is referred to as the burden of proof. Under our constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove her innocence. As I told you earlier, she enters this courtroom an innocent person, and you must consider her to be an innocent person until the state convinces you beyond a reasonable doubt that she is guilty of every element of the alleged offense. If, after all the evidence and arguments, you have a reasonable doubt as to the defendant having committed one or more elements of the offense, then you must find her not guilty. Members of the jury, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a fanciful or frivolous doubt, nor is it one that can be easily explained away. Rather, it is such a doubt based on reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proved all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. Please remember that in order to reach a verdict in this case, whether it is guilty or not guilty, your verdict must be unanimous. I'm now going to discuss the definition of the crime with which the defendant is charged. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts, an intent and an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what her intentions were. The word intent refers to what a person mentally believed her physical acts will accomplish, and the word act refers to a physical deed. The state has the burden of proving beyond a reasonable doubt a separate intent and a separate act for each crime charged. Thus, for a person to be guilty of a crime, she must have done the following two things. She must have mentally intended to do something that is criminal, and she must have physically acted to do something that is criminal. Unless a person both intended and acted to do something criminal, that person has not committed a crime. Many people do not realize that sometimes the only reason two identical acts are given different names is that they refer to different intentions. For example, assume that two drivers of automobiles hit a person crossing the street. If one of the drivers intended to hit the pedestrian and the other one did so recklessly, they would not be charged with the same crime, because while they both committed the same act, they had different mental states. Now, whether the defendant acted with the required intent is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances and evidence in deciding whether or not the state has proved that the defendant acted with the required intent. Charge number 571918C alleges that the defendant committed the crime of resisting arrest or detention in that she knowingly interfered with a person she recognized to be a law enforcement official seeking to effect her arrest when she struggled with Officer Elston, Sergeant Muchi, and Sergeant Patty as they attempted to handcuff her. The definition of this crime has four parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant physically interfered with another person, and 2, the defendant knew the other person was a law enforcement official, and 3, the official was trying to arrest or detain the defendant, and 4, the defendant acted knowingly. These are the elements of the crime of resisting arrest or detention. Certain terms in the definition need to be further defined. With respect to the first part or element, as indicated, the interference must be physical. Verbal protests alone do not constitute resisting arrest or detention. With respect to the third part or element, it does not matter whether the arrest or detention was illegal. The state does not have to prove that there was a valid legal basis for the arrest or detention. Law enforcement officials are justified in using non-deadly force upon another person when, and to the extent they reasonably believed it necessary to effect an arrest or detention, unless the officers know that the arrest or detention is illegal. The fourth part or element refers to the defendant's mental state. A person acts knowingly when she is aware of the nature of her conduct. The state does not have to prove that the defendant specifically intended or desired a particular result. What the state must prove is that the defendant was aware that her conduct would cause the prohibited result. Whether the defendant acted knowingly is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances and evidence in deciding whether the state has proved beyond a reasonable doubt that the defendant acted knowingly. Members of the jury, the principles of law that I have given to you are intended to guide you in reaching a fair result in this case, which is important to both the parties in the courtroom and the court. You are to exercise your judgment and common sense, as I said before, without passion, without prejudice, and without sympathy, but with honesty, understanding, and due deliberation. When you have considered and weighed all the evidence, you must make one of the following findings with respect to each charge, with respect to the charge that is before you. If you have a reasonable doubt as to whether the state has proven any one or more elements of the offense charged, you must find the defendant not guilty. However, if you find that the state has proven all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. As I've said before, your verdict must be unanimous. All 12 jurors must agree on your verdict. When you have arrived at your verdict, let the bailiff know, and you will be returned to the courtroom where the foreperson will render that verdict orally in response to questions from that the clerk of court will ask you. The foreperson should see to it that the jury takes up the issues that are before you. He or she should see to it that each juror has a full, fair, and adequate opportunity to present his or her views, positions, and arguments with respect to the law and the evidence. You should choose the foreperson as your first order of business. Each juror's verdict must be his or her own, and it should not be made out of a need to agree with everyone else. Yet, in order to bring 12 minds to the same decisions, jurors have to respect and listen to one another's opinions honestly. I suggest that deliberation is a three-stage process. First, each juror should decide for yourself your opinions and views of the evidence in the law. Second, you should listen to what your fellow jurors have to say about the evidence in the law. Third, you should speak up and let your fellow jurors know what your opinions and views are of the evidence and the law. You should remember these two rules when you disagree with other jurors. 1, respect and consider the opinions of other jurors. 2, but in the end, reach your own decision. If, during deliberations, it becomes necessary to communicate with me, you may do so only in writing, signed by the foreperson or one or more members of the jury. Please give that note to the bailiff and he will bring it to my attention. No member of the jury should ever attempt to communicate with me except by a signed writing, and I will communicate with you on anything concerning the case, either in writing or orally in the courtroom. At the risk of being repetitive, let me say again that nothing said in these instructions is intended to suggest or convey in any way what your verdict should be. The verdict is exclusively your duty and your responsibility. Thank you for your attention. In a moment, I will select the alternates first. However, I would like to see the parties at the bench. At this stage, ladies and gentlemen, I have to select 2 alternates. The alternates must remain in the courthouse in the unlikely event that we need to substitute an alternate for a juror because of illness or family emergency. That's why we ask the alternates remain. I have here a container with 16 pills in it, because sometimes we have 16 jurors. We'll just draw numbers by random to designate the alternates. 15 doesn't work. Number 8, you just remain seated for a moment, ma'am. I'll tell you what's happening. And number 6. So you two folks are alternates. That would be Ms. King and Ms. Escalera. The bailiff will take you to a different location, separate and apart from the jury, but as I said, you have to remain in the courthouse until a verdict is reached. The remaining jurors shall retire now, and now, of course, not only can you talk about the case, that's really what you're supposed to do. And oh, by the way, ladies and gentlemen, there's some typos that I'm going to fix, but you'll get a copy of the written instructions. So no one really expects you to remember all that stuff that I just told you from memory. So you'll have a copy of the written instructions in about 5 or 10 minutes.
All right. Just go and get your stuff. You ready? Thank you.
Senator, you have to remain in the courthouse. There could be questions or verdicts, so you have to stay here, okay? I don't know whether you're planning to go anywhere, but you got to stay here.
Just in the courthouse?
In the courthouse.
Can I, like, step outside for a couple minutes to check a meter?
Yeah, but only for a couple minutes because you'll get paged and you won't hear it.
Okay.
Judge, do they pick their own foreperson?
Yes, it's in the instruction.
Okay.
Yeah, because the jury could have a question in 5 minutes or 10 minutes or an hour, they could have a verdict.
Well, if I step outside, I won't be outside for more than 4 minutes.
Okay, yeah,
If I
check
hear
the
you
meter,
paged,
but otherwise you have to stay in the courthouse.
And I have a friend who will come out and tell me if they're going to.
Okay, good enough.
Am I also have to write this down?
Yes. Do they have the discs?
They did not.
And apparently there's a gentleman in there that feels comfortable
Correct.
running this.
And I can probably just, there's only one of them.
We'll all go in together so that
Okay.
we don't run into any problems.
Yeah, one of them is very easy to open, they just click on it because it's ABS. The other one, they just have to make sure to open in QuickTime. And that way, otherwise it's sideways instead of right side up.
Ms. Hager, do you want a record of this? Explaining to the jury how to use the, just making sure they know how to operate
Well, you said we're all gonna.
we're all gonna go in, but there's no record. I'll have to bring them in the courtroom if we're gonna have a record.
And if you want to see, I just want to show you that it's clean too, that there's nothing on here.
I'll shut the alarm, Judge, I'll be right
If
back.
I go into logo
I'll tell you what
documents,
we're
there's
gonna
only
do here.
voice files.
We'll get, bring them in the courtroom, bring the jury in,
And then my documents.
bring the jury in.
And then so we look at all these.
I've got a pro se. So
This has to be connected to our network. There's Microsoft, but you'll see that there's, well, there wasn't anything over there.
You want me, I just got my notebook?
Sure.
I don't think that they can get into this, but I'm gonna check. Yeah, they're able to get into it.
Are they unable to get into all of those?
Yeah, they should be,
files?
because it was on a hard drive. I'll double check right here. The only thing I'd be concerned about, and I don't know if you know how to do this, is to get rid of this, and the reason is because I had gone to listen to the district court, so you can see how it says district court.
Just
That's-
delete it.
That's what I'm trying to do, Jed, because it's on, you know how it comes up on the getting started part on the Microsoft Word? They shouldn't be going into Microsoft Word anyways, and you can't pull up the document. My concern would be is if they pull up Microsoft Word by accident, they'll see under, like, the previously open files is something titled Ager Catherine testimony from district court. If you know how to delete that, that'd be great, that actual title.
All rise for the jury, please. seated.
To get into the document, or you can just see this one.
I see, she just,
Yep.
You just drag it inside of the screen.
oh, I see what you're saying.
Yeah. And then we'll click on it and see if it comes back up that way.
Pardon?
And then just make sure it comes up that way.
Mike? Yeah,
Awesome.
okay.
That shouldn't be hooked up to anything. Oh, it is. Alright, I guess it'd probably be easier if we're here when, the court instructions.
No, it won't. Just,
And I told her this doesn't happen.
mine's on. Okay. How are you gonna move this document?
Usually I.
Judge, I'm gonna be able to,
Usually, you mean to get to the DVDs?
Yeah.
I usually go to my computer and then like this, and then once it comes up, I'll click on it and say open in a new window. And then go into the window.
Right, but they've gotta change the.
The microphone's on, Judge.
That's okay. We're just trying, thank you. Here's the situation, members of the jury. This is on because we're short money, we don't have any number of projectors and screens. The projector and screen is now in another courtroom. So the DVDs are accessible, but on the computer. And the computer, it has some other, it has, yes.
You can project that onto the whiteboard.
If we don't have the projector. Oh, we do have the
We do.
projector.
And actually, I think the trial ended early that it was going to be used in, so I could ask somebody to bring it back up, the actual screen, if they wanna watch it in here versus the laptop, I don't know.
Do you want to be able to manipulate it, or you
I
just,
believe they want to see it up close.
they want to see it up close?
They want to see it up close.
All right, well, let's do this then.
Do you want me to leave the laptop, we can get it up, and then we can leave the room while they manipulate it, and then when they wanna change videos, we can come back in with the second video?
Who's computer literate over here? It's pretty simple, it's just we don't want you in anything else.
I built these systems.
Oh, you did? Okay. So, you will not access anything else on the computer? Is that satisfactory to both parties? Satisfactory to you, Ms. Sager?
Yes.
Pardon me?
You can enact my security clearance if I do.
All right, then why don't we let them take the computer with the DVD back into the jury room? You want the projector, you want to be able to project onto the whiteboard? And,
Yeah, they can just roll off this, and that's fine.
turn to like you want to tell him where the, it's on a DVD, so you just open the DVD drive, you know what to do. Yeah. Okay, you watched her do it. I know, it's not rocket science unless you don't know how to do it, then it is.
I'll say to
Yeah, all set.
All right.
Are we all set to leave our stuff in the jury room?
Yes, there's nothing else going on in the book.
Thank you, Dan.
Please be seated.
Would the defendant please stand and face the jury, and would the foreman please stand? Madam Foreman, has the jury reached a verdict in this case?
Yes, we have.
How say you, Madam Foreman, in charge 2011 S1052, charging defendant with resisting arrest? How do you find guilty or not guilty?
We find guilty.
You say, Madam Foreman, that the verdict is guilty. So say you all, ladies and gentlemen?
Yes.
Thank you.
You can have a seat now. Thank you very much, ladies and gentlemen, for the service you performed, and I'll be back to speak with you shortly.
All right. Thank you.
Sagar, do you want to proceed with sentencing today, or do you want some time to,
Today's fine.
today's fine? Standard recommendation?
The state was just going to ask that what was imposed in the district court be imposed, Judge.
What was imposed in the district court?
My understanding, if I can read the back of the complaint correctly, is that she received 90 days suspended for a period of 2 years, good behavior, meaning no felonies, misdemeanors, or, my understanding, probably major motor vehicle violations would be my guess.
Does she have a record?
I don't believe so, Judge.
Sagar, how old are you?
18.
She was convicted of the disorderly conduct down below. That was the reason that she was arrested in the first place, Judge, when she
Oh, she didn't
failed.
appeal that?
My understanding is that it was a violation level offense.
Oh,
the government
violation level
covered.
It's a violation level, and it's currently in appeal to the Supreme Court.
And other than that, Judge, she has no other convictions.
Anything you care to say?
Well, I think that all the time and money I've spent on this is punishment enough.
Is there anything else you care to say? You're a senior in high school? Do I understand that?
Yes, I'm graduating next week.
Okay, where are you in school?
Keene?
And what do you want to do with your life, Ms. Agar? What do you want to do after high school?
Various things. I want to work and spread ideas and learn. And I probably won't go to college, but I plan on taking various classes of things that I'm interested in learning.
You know, what do you want to do? Do you have any concept of what you'd like to do? You said you want to work. Do you have any idea about how you'd like to spend the next 10 years of your life, or the next 5 years?
You mean like a career?
Not necessarily a career forever, but what you'd like to do in the next 5 years.
Well, like I said, I want to take some classes and maybe, I'd like to work. I'd be interested in working with horses if that's possible. I want to continue learning and sharing ideas with other people.
I understand that you were seeking to make a political statement in front of the Manchester Police Department. Yes?
I don't think there was anything political about what I was doing. Like, honestly, I wasn't even aware there was a protest going on until I showed up. I was coming to Manchester to see one of my friends and visit and watch a movie or something, and got a text message when I was around the area of Hooksett saying that one of my friends had been arrested, so I decided to go over there and see what was going on, see when he would be released. And like, I wasn't doing anything to make a political statement. I didn't write with chalk, I didn't hold signs, I was just standing on the sidewalk.
I want to check something. We're going to take a 15-minute recess. We'll be back.
All right.
Here.
He doesn't know what to do. He's handcuffed by the law. He doesn't want to do anything.
Yeah, that'd be great if they're done with the equipment.
Well, sure, that's what he has to do. He has to.
Gentlemen, court, all rise. Please be seated.
Yeah, that's fine. That's fine. Would you stand, please? What I'm going to do, Ms. Agar, I'm reducing the district court sentence. 2 years good behavior really puts you out 5 years to annul your conviction. You're 18 years old. And I want to give you the opportunity to seek an annulment and address this. An annulment doesn't completely wipe it off your record, but it can have very positive effect in terms of jobs, and if you decide you want to go to college or you decide you want to go into a profession that requires a records check, an annulment can really aid you in that. I don't want to see this have this kind of lifelong impact. You're 18 years old, you're not going to listen to me because I'm old enough to be your grandfather, but I'm going to tell you this anyway, because I have a son and I grew up in the 60s and I understand a lot of what's going on. You have to think about what you're doing. There are ramifications in life, and there are consequences, and they can sometimes be far more draconian than one can ever imagine. And it's just, I don't want to see you ruin your life when it's just beginning. I just don't want to see you do that. You conducted yourself here commendably. You tried the case. The jury just was very impressed with the way you handled yourself. I was as well. I thought you were respectful. I thought you did a very good job. It was impressive. You have a lot going on, and I could tell just the way you've conducted yourself throughout these proceedings. This is a completely foreign element to you. You were poised. You were respectful. You were competent, and I could just see that you got a lot of good things going on for yourself, and I just don't want to see you ruin your life. I'm just going to give you a 30-day suspended sentence. That's it. And suspended it, and I'm going to suspend it for just a period of 30 days, so that at the end of 30 days, the 3-year period starts to run, and you can have your sentence annulled in 3 years from the end of the sentence.
Okay, so 30 days from now, it'll be like the suspended sentence will no longer be.
It will no longer be hanging over your head. That's correct.
Okay.
And I'm giving you within 30 years, within 30 days. The form says years, and I just wrote 30, and I just changed it. But I want to tell you that if you get yourself in more trouble, this is on your record, and the judge that imposes the sentence is going to look at it, and ultimately what happens is things become more serious, and all of a sudden you're tracking a criminal record that follows you forever, and lo and behold you decide you want to be licensed to do something, and the licensing authority looks at the record and they won't license you. And I don't mean just to be a lawyer or something. There's so many licensing restrictions, and you're 18 years old, you have no idea what you want to do with your life. And I don't want to see this single episode having the kind of impact that can affect you. But I want to tell you that if you find yourself engaged in, and I understand what you told me, and that's part of the reason why I'm doing what I'm doing. There are ways to go about civil disobedience, if that's what you choose to do, and there are ways not to go about it.
Can you suggest how you would go about civil
Well,
disobedience?
you have to think about the consequences, and you have to think about how it will impact you. We live in a very politically correct world right now, and there are substantial consequences for what people perceive when they're doing it to be insubstantial behavior. And all I can say to you is you need to think about what you're doing, and you need to think about why you're doing it. And you need to be aware that it can have significant impact on your life 5 or 10 or 15 years down the road, and can prevent you from doing things you really, really decide you want to do. I mean, you've demonstrated to me that you're thoughtful and that you're intelligent, and you have to make decisions that are good for you in the long run. And I know at 18, the thought of compromise is an unacceptable reality. But think about what you're doing and think about why you're doing it. I hope we never see you here again.
I hope so too, but we do have some of my friends that have to come here, and I'll probably be here to support them.
That's fine. I mean, I'm not telling you that you shouldn't support your friends. That's not what I'm saying to you. I'm just saying to you that the decisions you make have great impact on the rest of your life, and you need to think about that. That's what I'm saying to you. All I can say is that, and I know your friends I don't know whether they're in this court or not in this court, or they're coming to this court, but they made their own choices in their own lifestyle. But you've got to make choices for you, because if you come back and you're back here with the same sort of thing, I can assure you that the next time around, the judge won't be nearly as understanding, because it will appear that that's what you've chosen to do, and there are consequences to that kind of activity. There just are. And the next time, it could be longer suspended time, and the next time it could be jail. And it's not a nice place. It really isn't.
I've heard.
So I hope you'll make good choices, and I hope we don't see. When I say not to see you here again, I mean where you're sitting. You can come and sit back there as many times as you want. I just don't want to see you sitting here again. Okay?
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeen.com also has comments and discussion forums so you can be heard. Freekeen.com.
I should be in Keene, New Hampshire with the Free Staters.